The Honourable Mr.
For 3 hours in Port of Spain today, attorneys for the Belize Bank Limited and the government duelled over whether the government should proceed to enforce the $90+ million judgment in favor of the bank issued last November or scrap it. Senior Counsel Eamon Courtenay told the 5-judge panel that only they can solve this conundrum.
The only method of enforcement available to us is the certificate under Section 25. It specifically says so. When the government is concerned, get your certificate and serve it, and they shall pay.
Okay, let me ask another way. What is it do you expect or are asking this court to do?
We are asking the court to declare that the order has not been paid, and 2, to issue an order saying to the Minister of Finance that you must pay.
Why can't those requests and claims be made at the trial court?
Because, Your Honor. Because, Your Honor. Well, I won't say that they can't be made. They can be made at the trial court. But what I'm saying to the court is that in our respectful submission, we are entitled, based on the authorities that we have, to come here in the limited circumstances of this case for that relief. If we go to the trial court, it is clear as day that we will get the order of mandamus, we will serve it, and what? The government will go to Parliament and vote no.
But might this be premature? After all, following Friday's budget reading, the debate is scheduled for the 22nd and 23rd of March, and the original bill is still on the table. Courtenay said that on instructions from his clients, they are prepared to wait and see where the parliamentary debate goes and if the funds are allocated.
And we weighed this whole issue of Parliament tabling the bill and not doing anything with it, we are prepared to wait for the House to meet next week and let us see what happens. If the money is appropriated over terms, that's the end of the matter. We are prepared to wait for that and to see whether the fact will be established and whether the government of Belize is going to say to the C.C.J, we don't care. We have a right to decide. I don't want to read to this court some of the things that have been said by the ministers there in the evidence. But we are prepared to step back and ask this court to adjourn this matter and have the Parliament speak. This is a fundamental issue, Your Honours, and with the greatest of respect, this court, for the benefit of the region, has to pronounce on this matter. And if it is that an essential element is the decision of Parliament, with respect, I would like an adjournment.
Meanwhile, the government is seeking a reduction in the amount of interest to be paid and also questions the validity of the certificate based on compliance with either the Arbitration Act or the Crown Proceedings Act. Queen's Counsel Dr. Ben U.H.S, appearing for the government, maintained that Parliament still has final say and that the court should be careful in exercising what jurisdiction it has. But he got into a back and forth over whether the government is being advised to disobey.
I'm just intrigued that the government will be getting this kind of legal advice. It's a little bit foreign to my thinking in terms of what I considered to be the position which you had advocated earlier, that the government would have had an obligation to pay. Because that was what you had said earlier. That's what triggered my inquiry. When you offered the point of view that the government had an obligation to pay. So I don't see how in the same breath you can say that it has the right to decide not to pay.
It would not be the government, with respect, that would be making that decision.
It
would be Parliament. With great respect, Mr. President, it's not the same thing on your authority in BCB and Belize, where the court emphasises that although there is a close connection between the executive and Parliament, the Constitution of Belize, and I quote from paragraph 42 of the judgment in that case, carefully distributes among the branches the unique functions that each is authorised to exercise. and in this case, it is the exclusive remit of Parliament to decide whether or not to make an appropriation of funds, and that cannot be changed by judgment of the court.
But is that tantamount to disobedience of a court order? Or, as President Byron put it, is the government playing a game? U.H.S said no.
The court order, Mr. President, is not addressed to Parliament. The court order is addressed to the executive, and it is very important to bear in mind, as you did in BCB, that there is a meaningful difference between the executive and the Parliament. So your order would not be affected. The ability of the executive to satisfy it would be. If the court wished, for example, if a new case was brought seeking mandamus, and if the provision allowed for mandamus, which this one doesn't, then there could be a conditional order of mandamus requiring satisfaction upon the availability of lawful funds. But the court couldn't, consistently with the separation of powers and without provoking a constitutional crisis, require a member of the executive to pay a judgment which he was not lawfully in funds to pay.
But that's playing a game.
With great respect, Mr. President, the separation of powers is not a game.
But that is how it sounds just now.
Well, it's to my great regret that that's how it sounds, but this is a principle that flows directly from the struggles between the executive and the Parliament for control over the purse strings of government.
And that means it's still in Parliament's hands, as the C.C.J retired following today's arguments, to await that outcome. Aaron Humes reporting for News 5.